All rise, please. The United States District Court for the Western District of Washington is now in session. The Honorable James L. Robart presiding.
Please be seated. The court will call this matter.
Case number C-12-1282, United States versus City of Seattle. Counsel, please make your appearances for the record.
Good afternoon, Your Honor. Christina Fogg for the United States of America.
Thank you.
Good afternoon, Your Honor. Tim McGatt for the United States.
Good afternoon, Carrie Key for the United States.
Good afternoon. Paul Olson, Assistant City Attorney for the City of Seattle.
Merrick Bob, Monitor.
Good afternoon, Your Honor. Pete Holmes, Seattle City Attorney. And if I may, Your Honor, before the remaining council appearances are entered, I'd like to let the court know that we're joined today by Mayor Jenny Durkin, Councilmember Lorena Gonzalez, and former Councilmember Tim Burgess, along with Chief Carmen Best, our Inspector General Lisa Judge, as well as the OPA Director Andrew Meyerberg. Thank you.
Carola Cowart for the City of Seattle.
Your Honor, Lisa Dugard for the Community Police Commission, and I'm joined today by one of our co-chairs, Harriet Walden, as well as Commissioners Colleen Echohawk and Emma Takagi, as well as Executive Director Fe Lopez and most of our staff. Thank you.
All right. Well, welcome to everyone. Council, I asked you in to stay as up to date as I can be in regards to the current matters. The city filed a letter in the docket which indicated that the tentative agreement, as you all refer to it, is pending city council consideration. I read from what I assume is a relatively reasonable source that that's likely to occur, the consideration, on November 13th, 2018. Since, as we normally do, I've asked that this hearing be videotaped so that it's available to the public, I'll interject at this point that the City Council, as I understand it, has no ability to amend the tentative agreement. In my order setting up this hearing, I ask that you be prepared to discuss with me what the next steps are going to be. And we now know that's City Council consideration on November 13th. Secondly, what information could be shared about a timeline, and that appears that we're going to have something happen on November 13th. And then what I thought would be tempting to you, a limited disclosure of your view of the tentative agreement. And then also your advice to me on the timing of the court's involvement. To put everyone out of their misery, I'm not going to make any substantive rulings today. I view this as providing me information so that I can move forward consistent with the terms of the settlement agreement and the memorandum of understanding, which once again you have adopted some terminology that you refer to as Phase 2. By way of background, I thought it was appropriate to have the city go first today, since in effect they are the sponsoring institution. That would be followed by the United States, and that would be followed by the Community Policing Commission. What I hope to obtain from that are particularly limited to these issues of your preliminary views on the tentative agreement, and also some sense of when you think it is appropriate for the court to become involved. Since there seems to be some confusion, particularly in the press, I will stress again that I am not going to be ruling on the tentative agreement today. I'm not sure what I would rule on, since it's not been formally adopted, and secondly, we don't know if there will be changes to it, a rejection of it, it passes. Those are all items to happen in the future. I will put to death an argument made by the city, which that since I gave preliminary approval for full and effective compliance under the prior regime, that must mean that the tentative agreement should pass full and effective compliance. That's, in my mind, not a serious argument, and the city should no longer try and waste its time arguing things like that. Next, I would note that the court administers the settlement agreement and the memorandum of understanding. Sometimes you refer to that as the consent agreement. The accountability ordinance is not directly before me. It is the obligation of the City Council to consider it. After that happens, the question is, as the regime presented by the city, does it meet the terms of the settlement agreement and memorandum of understanding? And so that you have a better sense of my view of this, I see the memorandum of understanding and the settlement agreement as conveying the agreement of the parties, but also as establishing an obligation for constitutional policing. And therefore, when you are discussing my prior comments on the accountability ordinance, you should see them as a floor for your action and not some ceiling. And then finally, once the City Council votes to either consider the tentative agreement and approve it, or if it decides not to do that and does whatever you're going to tell me happens next, the court, regardless, will continue its current role of administering the consent agreement, even if that means without a new contract. So I'll hear from the city first, I'll hear from the United States second, I'll hear from the CPC third. I've given you each 20 minutes, and then I have some comments about where we go from here.
Your Honor, I will address the topics raised in the court's order and additional issues raised in the parties' filings. Before that, with leave from the court, Mayor Durkan is here to address the tentative agreement, its impact on continuing reform, and the obligations of the consent decree.
You know, when Ms. Durkan was the U.S. Attorney, she had to abide by the local rules of the Western District of Washington that provide you only get one speaker. I find this with some pleasure then to say if she stands up, I can ask her questions. And it is coming out of your time, and you have 20 minutes, so if that's how you'd like to spend it, that's fine.
Thank you, Your Honor.
Ms. Durkan.
Thank you, Your Honor. I appreciate the opportunity to address the court. I'm cognizant of the court's role in this matter and the roles of this court. I think that the court has laid out well for us and the parties the context of the ruling and the court's jurisdiction. I think it's important to also set forth for deciding this motion or deciding future motions and context for this status conference that some more historical context is appropriate. We in the City of Seattle have had episodic reform for a period of over a decade, and many of the people in this courtroom have interspersedly been involved in those reforms. I first met Councilmember Gonzalez, for example, and was able to work with her in 2008 when we both served on an oversight panel looking into some misconduct related to the Seattle Police Department. Before that, I served for 3 years as a citizen observer for the Firearms Review Board and sat for 3 years in every police shooting case there was. Sat on an oversight board that created the OPA. We had episodic reforms, and when I was U.S. Attorney, as the court is aware, we had a series of events that led a number of civil rights groups, including those who are present in this courtroom today, like co-chair Harriet Walden. Doing that in historical context, this U.S. Attorney's Office decided to launch an investigation in the Seattle Police Department and constitutional policing in conjunction with the Civil Rights Department. Many cautioned at the time that the U.S. Attorney's Office should not be directly involved and lead on that because of the nature that this office had with law enforcement and the very fine line that we would have to walk. But we decided then, and in conjunction with the Civil Rights Department, we knew that in talking to monitors across the country, talking to others who'd worked with federal judges, talking to others involved, that there was no one-size-fits-all consent decree for reform in a police department, that you had to have local people looking at things directly. So we did that, and I think that while it was risky for our office at the time, this court knows that in doing so, we have, I think, got it right in many ways in the city of Seattle, where other cities have failed. We know that because of the great work done by the Seattle Police Department, by the civil rights groups, by the Community Police Commission, by the monitoring team, but mostly because of the oversight of this court, that the Seattle Police Department has been found in full and effective compliance. I understand and appreciate the court's cognizance of that doesn't mean that the new TA would not be subject to further scrutiny by the court, but I think that that full and effective compliance showed that the process we used here brought about constitutional policing. And one data point that I think we can use is the recent report filed related to crisis intervention. Those data show that what we're doing is working. There has been a significant increase in 2017 and 2018, almost 16,000 crisis contacts. Of those crisis contacts, less than 2%, approximately 1.7%, even resulted in force being used. In those instances, almost 75% involved the lowest form of force, type 1 force, which before the consent decree was not even captured by the Seattle Police Department. It shows that the work that the Seattle Police Department, the monitoring team, and the CPC have been done has worked on the streets. Against this backdrop, we restarted our negotiations with the Police Officers Guild. I think it is highly unusual and may be one of the first times in our country that an original signatory to a consent decree later was required to be the chief executive of the city required to implement that consent decree. You have with City Attorney Holmes 2 of the 3 signatories. I will tell the court that in sitting down in those negotiations, forefront at our mind at every step was the consent decree documents. Public trust, but we also had to have the right to bargain. As this court is aware in previous orders, it specifically noted that it had not authorized the entire of the accountability ordinance. Councilmember Gonzalez is here should the court decide it wants another voice on those issues. But we knew that we had the ordinance there for against which reforms we wanted to make. The court also required the city to give a list of those items that had to be bargained under law with the Police Officers Guild. And I, being a signatory to the consent decree, but more importantly, having been involved in oversight reforms for almost 2 decades, was going to make sure that we did not go backwards on reform in any significant way, that we sat at the table and bargained everything we had to bargain, that everyone walking into those negotiations knew we could not dictate the terms of the ordinance in a contract because that would be an unfair labor practice. We actually had to bargain. Throughout the process, we consulted with the council through the LRPC process, the Office of Inspector General, the OPA, and the CPC. We believe that every one of the parts of the tentative agreement not only meets the letters of the consent decree, but also moves forward significant reforms under the ordinances. For example, the Office of the Inspector General, I believe, will be one of those things moving forward that will maintain public trust and have an oversight function once the monitor no longer exists. Which, no offense, sir, we hope that happens sometime. But to do that, that Office of Inspector General has to have full and unfettered access, must stand up as a robust oversight group. That can only happen through bargaining, which we're able to get. We also were able to have removed all of the unfair labor practice unfair labor complaints, including those for body-worn cameras. We now know SPD will go forward. We also expanded the 180-day rule so that in those cases involving either bias or most significant force, there's a way to recalculate it so we do not end up in those situations like we had before where public trust was undermined by someone being fired then reinstated. This tentative agreement also ensures a very important thing. Our police officers, who did everything asked of them by this court and by our city, were found in full and effective compliance, have been working since 2014 with 2014 salaries in a city that is growing more expensive and asking them to do a job that is more and more difficult. We believe it is central to public safety to be able to pay enough to keep and train the best officers in the city of Seattle. In closing, I would say that this was our attempt to do three things. One, make sure that we preserved every aspect of constitutional policing as required under the consent decree. Second, to continue those most significant reforms needed for the Seattle Police Department. And third, ensure public safety for the people of Seattle. This tentative agreement does all three of those things. The court will have some questions on what happens next. I believe, in my best judgment, should this tentative agreement not be approved by the City Council, all three of those things could be jeopardized moving forward. So with that, Your Honor, if the court has any questions for me, otherwise I would defer to counsel.
Well, I do have. Did I understand you just to say that the accountability ordinance is not law, but rather a goal in your contract negotiations?
No, sir, you did not. I was referring to the fact in the court's previous order where the court has specifically said that it had not yet approved the accountability ordinance and that wanted to approve it after bargaining in the court's previous order. It is clearly the law of the City of Seattle, but we were required to bargain certain elements. We cannot take a city law and impose it through the bargaining process. As the court knows, both federal and state law require us to bargain in good faith, and we did so.
And do you agree that the court is not bound by that requirement?
By federal law, Your Honor?
By the requirement, as you express it, that in the face of an alleged unconstitutional police practice, that I can't prohibit it.
No, Your Honor.
I have to go bargain with the union?
No, Your Honor, I do not believe that. I believe that this court has the ability to require constitutional policing, and I believe it is clear that the tentative agreement reached does not compromise constitutional policing and, in fact, advances it. Those things that were set forth in the accountability ordinance, while all good measures and important measures, differ from the consent decree in a number of regards and go beyond it in a number of regards. And those features of the accountability ordinance which were most important, including the Office of Inspector General having full and unfettered access, getting civilians in the Office of OPA, changing the 180-day rule, those things that would go.
You're using up your time, counsel.
Sir.
Let me try one more time. You said, and I think I wrote this down correctly, local people looking at things directly. You championed, you created the CPC, and now they're saying that the current tentative agreement is not in the best interest of the city. How do you respond to that?
I think that the CPC forms a very vital and important function in the city of Seattle for police accountability. It is their job to always question, to push, and to ask the question of, have we got it right? It is not their job to sit down at the bargaining table, and in fact, that's prohibited. But our response is, well, they may want more, and we all want more reforms, and will continue. These reforms that we passed are the most essential reforms. They come right out of the ordinance. They make sure that we can continue on the path of constitutional policing, and they meet the terms of the consent decree.
All right. Well, let me offer one gratuitous statement. Salary is not my issue. I'm perfectly happy to have the salary provisions, with one exception that I'd like to hear some discussion about, go forward. So I think we should just take salary off the table. I agree with you that there's not been a salary increase since 2012. One is deserved. If this is the agreement that's been reached by the parties, then it ought to be implemented, and it ought to be implemented promptly. So I see that creeping back in. I saw it creep in what I thought was a pretty sleazy way prior to the finalization of the contract, let's take that one off the table, and let's concentrate on the constitutional reform questions.
And I address that, Your Honor. Obviously, as the chief executive's salary was an important part to negotiation, and in any negotiation, if you want people to negotiate, you have to offer them something. But I'll stress again, there is nothing in this tentative agreement that sets back this court's order to require constitutional policing. In fact, it advances constitutional policing in the city of Seattle. It advances reforms. Those items that the CPC wishes us to pursue, we can continue to pursue in one of several ways. For example, if any of the items they've struck actually cause a problem, which we don't think they will, the Office of the Inspector General, as well as the Monitor, can call it to our attention, and we can recalibrate and have the ability to reopen the contract. But nothing in this tentative agreement is inconsistent with the consent decree, nor is it inconsistent with the principles of reform.
You've left your lawyer 5 minutes to tell me that.
Perfect.
And then I'll hear from two other parties. Thank you, Mayor. You have 6 minutes left, Counsel.
Your Honor, I'll address timing briefly and then talk about what would happen if the tentative agreement is rejected, and then address some of the issues raised in the filings, unless the court has direction otherwise. As the court mentioned earlier, our brief indicated that the next time when the council could vote on the tentative agreement, could consider and vote on the tentative agreement, would be November 13th. And I can reaffirm that Councilmember Gonzalez, who's here today, intends to bring to a full council vote the tentative agreement on Tuesday, November 13th. She can answer any additional questions the court may have about timing or process of council. As to timing of the court's review, the city would welcome input or guidance from the court at any time. If the tentative agreement is voted on, approved, and then signed, and it becomes a final collective bargaining agreement, then if it would be helpful at that time to the court, the city would be happy to provide more extensive briefing on the tentative agreement and the accountability ordinance.
Well, one of the things that I'm looking for today is to find out who's going to help me in that process. At some point, this entire package is going to come back on a motion to terminate the consent agreement or consent judgment. I'm not sure what form that would take. And what I don't want to find is that all of a sudden I'm supposed to be looking through all of the papers and I don't have a very passionate debate about is the right thing, is this the wrong thing? And that's where I'm looking for some assistance, is when does that happen and how does it happen?
The city would envision the court considering a final collective bargaining agreement and the accountability ordinance sooner rather than later. So we weren't contemplating that the court would wait until there's, for example, a motion in 2020 to terminate the consent decree if that were to take place.
The motion would be a finding of full and effective compliance, which, given the passage of time and the way the consent decree is drawn up, would more or less automatically end the consent decree at that point, because the prerequisite conditions had been established.
Yes, Your Honor. The city would welcome guidance and a final ruling on the future possible collective bargaining agreement if it becomes finalized before that point.
All right. So let me ask you a question. One of the things that your pleadings, and they're substantial, one side says, for example, that there is a pay premium for an officer who consents to wear a body camera. Is that in the agreement?
Yes, Your Honor. There's a 2% pay premium for officers who are required to wear body cameras.
And how can you, and as I understand the current status is they're required to wear body cameras at this time.
Some officers are not required to wear body-worn camera. For example, when they're at their desk.
I understand, but let's talk about the real world here.
Okay.
What I hear you telling me is we're going to pay a 2% bribe in order to have people follow an order that I've already entered in the paperwork of this case. Is that true?
It's true that the tentative agreement provides a 2% pay premium to the officers who are required to wear body-worn video. But that is not unprecedented. The city did research on other cities and practices.
Counsel, I don't want to hear your argument what's precedent or not. What I want to know is it a variance from what I've ordered in this case? And your answer? I mean, I don't want to get into a discussion of the fine points, but I'm having a little trouble seeing these very broad, general statements about we've achieved, peace in our time, when CPC and others are saying, no, this is not the situation. I want to know how I get that issue in front of me so I can make a concrete decision based on the facts.
One procedural mechanism could be if the council votes to approve the tentative agreement and the mayor signs it and it becomes a final collective bargaining agreement, the city would notify the court, the monitor, and the Department of Justice that it has become a final agreement, and then there could be briefing filed by the monitor, the city, and the Department of Justice.
Okay, and what is the question that I would be answering at that point? Is it constitutional policing to do what you propose to do in the contract? Is it constitutional policing that's found in the ordinance? I know these sound like very academic questions, but they're the basis of my jurisdiction in this matter.
My understanding is the court would review both the collective bargaining agreement and to determine if it is consistent with the consent decree and with constitutional policing, and also the accountability ordinance as modified by the collective bargaining agreement.
All right. I haven't seen the argument that the accountability ordinance is modified by the collective bargaining agreement. Is that in your papers?
I don't believe we addressed that topic in our filing. As Mayor Durkin mentioned, the accountability ordinance itself, many of its provisions had to be collectively bargained under state law before they take effect. And in fact, the accountability ordinance itself contains a provision saying that under state labor law, the effective date of the provisions that must be collectively bargained does not occur until the city has complied with its collective bargaining obligations. So to the extent that any provision in the tentative agreement is inconsistent with a provision of the accountability ordinance, under state law, the collective bargaining agreement or the tentative agreement will supersede any inconsistent provision in the accountability ordinance.
And I was unsuccessful in putting words in Mayor Durkin's mouth, so I'll try with you. Are you telling me that if I find, for example, that a provision is unconstitutional, that I'm bound by state law because it was negotiated between the city and the union?
No, Your Honor.
Good.
No. I was trying to make the point that state law supersedes a local ordinance. It certainly would not supersede a federal law.
Well, the Constitution is a federal law.
Mm-hmm.
You're out of time. Thank you.
Thank you.
I hear from the United States Attorney. Ms.
Thank you, Your
Fogg?
Honor. Assistant. I have not yet achieved that full rank.
I apologize. Ms. Hayes.
The United States starts where it always does, with this case's governing document, the consent decree. As the court is well aware, the consent decree sets forth policing reform requirements in the areas of use of force, crisis intervention, stops and detentions, bias-free policing, supervision, and certain aspects of the Office of Police Accountability's operations. As you noted, in Phase 1 of this matter, SPD implemented these reforms and earlier this year was found to be preliminarily in full and effective compliance with our agreement. In Phase 2, the city is now conducting self-assessments to ensure continued compliance in each of these areas, while the DOJ and monitoring team independently review the same areas for validation. In addition to our role in reviewing the city's assessment work, it is also our obligation to make sure that the city does not change its policies or practices in a way that creates a conflict with or otherwise interferes with the continued performance of the city's obligations under the consent decree. With that context in mind, we are here today to address the court's specific questions with respect to our preliminary position on whether the SPOG TA complies with the terms and purposes of the consent decree, and second, at what point the court should review any agreement between the city and SPOG to ensure it does not...
Let me stop you for a second.
I'm sorry?
This is, as I mentioned earlier, being videotaped. There's probably some person who lives under a log somewhere who doesn't know what SPOG is. So why don't you explain?
Sure, I'm sorry. I should make sure not to use acronyms. So the Seattle Police Officers Guild is SPOG, and I've been saying the TA for the tentative agreement.
Thank you.
Yes. First, in analyzing the potential for conflict with the consent decree, it's important to remember the context in which this all arose. The accountability legislation, which the SPOG TA, if enacted, may codify or alter, was not mandated by the consent decree. While DOJ's 2011 investigation found some limited areas of concern with respect to the city's accountability systems, which were addressed in the consent decree mandates related to OPA, overall, DOJ found the city's accountability system was sound. However, when DOJ entered into the consent decree, it also signed a Memorandum of Understanding, or MOU, with the city. That MOU required that the CPC, quote, would review Seattle's current three-pronged civilian oversight structure to determine if there are changes it would recommend for improving SPD accountability and transparency. In other words, the city's obligation was mainly a procedural one, to review its accountability systems, not a substantive one mandating specific changes to them. CPC long ago discharged that procedural obligation. The CPC's review and recommendations, together with the work of others in the city, ultimately resulted in the accountability ordinance. However, even though DOJ did not mandate specific content for that ordinance, DOJ does have an obligation to ensure that the actions taken under the ordinance do not undermine compliance with the consent decree. Accordingly, DOJ reviewed the accountability ordinance through that lens and ultimately concluded it did not create a conflict. The SPOG TA, if enacted, stands to change portions of that ordinance and other aspects of policing in Seattle. Accordingly, our review for potential conflict with the consent decree is again appropriate. At this point, and as the court directed, we only have a preliminary position on whether the tentative terms of the agreement between SPOG and the city create a conflict with the consent decree. In a nutshell, it is this. We read with approval much of what the tentative agreement could accomplish, but we do not yet know enough about the meaning and potential impact of the tentative agreement to reach a final conclusion about whether it conflicts with the consent decree. If the City Council approves the TA, we would like the opportunity to do further due diligence, including further consultation with the city with respect to one provision in particular, Article 3.1 of the agreement, which relates to the burden of proof for officer termination. The consent decree does not specifically require that OPA apply a specific burden of proof in its investigations. However, DOJ did review OPA's practices as part of our investigation. And while finding OPA's existing system generally sound, the consent decree did mandate certain changes to it, including the creation of an OPA manual, which sets forth protocols for investigating serious misconduct, such as unreasonable force and discriminatory policing. We have reviewed the content of the OPA manual through its various revisions throughout the period of the consent decree. Accordingly, if the city were to adopt legislation that effectively alters OPA's practices or protocols, we would need to consider whether those changes conflict with the consent decree. For those reasons, we will want to know more about the impact of Article 3.1 on OPA's investigations. For example, we will want to know what offenses could be considered stigmatizing to officers, and whether this will expand the class of offenses that are reviewed under a higher burden of proof. We will need answers to these sorts of questions before we can reach a final conclusion about any conflict with the consent decree.
How are you going to get that done by November 13th?
Your Honor, your question is well-timed because my next portion of my argument relates to the timing of all of this. I believe that with respect to the timing, the appropriate point for review by both DOJ and the court is after any collective bargaining agreement is approved by City Council. At that time, the issue of conflict would become ripe for determination. We would propose, and I believe this is in keeping with what the city suggested, that the city notify the court if the TA is approved, at which point the court could set a briefing schedule for the parties to identify whether or not they believe there is any conflict with the consent decree. It would be between those two periods that we would conduct this additional due diligence. In other words, the city would notify us that it had been passed, and then we would begin to prepare briefing for the court, which would rely on additional consultation with the city to get answers to the questions that I have discussed.
Well, let me go back to perhaps the example that has received the most notoriety here, and putting this in the context of reality. If we're not dealing with police officers sitting at their desks, but we're dealing with police officers who are getting ready to enter an apartment, and they are being given 2% bonus to have body cameras on, I guess you could say that was part of the salary, which is outside of my purview. On the other hand, the right to not wear a body camera, which you were absolutely opposed to allowing that freedom. You wanted body cameras, and you've taken that position throughout this matter. The group that didn't was the CPC. Now you're faced with this dilemma of people can opt out, and there's no consequence, except to the public. I want to know how the government's going to respond to that. Are they going to change their position? I mean, I'm just using this as an example of things that are in the agreement. Are they going to change their position? Are they going to stick to their position? If we're going to stick to our position, then you're asking the city council to vote on something that the government ultimately is going to object to and toss into my lap. So help me with that.
Well, I'll do the best I can. I'm not sure I have all the information to help you with that specific question. The first part is I'm not sure I know that body-worn cameras were part of the consent decree in terms of being mandated by it. So I would have to look into...
The consent decree speaks in very lofty goals that have been implemented over the course of the last 6 years. Believe me, I've been here that long. If that's the case, I'm not going to accept the argument, well, it doesn't say, you know, the number of sergeants needs to be increased to 84, and anything short of that is going to be... What I am going to say is if you've identified areas such as excessive force, then I'm going to hold you to that obligation, and you're not going to be able to say to me, well, it's not mentioned in the consent decree, so it's not our issue. You need to look at this in a broader sense than specific provisions. You need to look at the purposes of the consent decree, which is your consent decree. You're the ones who sued them.
Yeah.
I'm just not going to let you off the hook here and now say, well, you know, it's not in there. Those words don't appear.
With all due respect, sir, I am not taking the position that the consent decree should be so narrowly read that any individual thing that is not specifically mentioned may not be within the purview of either our review or this court. I would agree with you there. But I don't think that we can read it as broadly as anything that relates to its purposes necessarily comes within the umbrella of the consent decree. I think ultimately those purposes still have to be tethered to the language of the agreement in some way.
Well, let me read you what I said last January, which was, does the proposed legislation conflict with the terms or the purposes of the consent decree? You had no objection to that at that time. That's the test that I intend to apply here. You know, does the proposed, in this instance, it would be acceptance of a contract, legislation conflict with the terms or the purposes of the consent decree? I understand that's a very broad and somewhat ambiguous standard, but that's the standard that I'm supposed to enforce.
So, if I may, I view it as the terms are the individual pieces of language, obviously, in the agreement. The purposes, bless you, are in part what we're reviewing for is how all of those individual terms work together to advance a purpose. But there's still a limit on what we can view as within the purpose of the consent decree. For instance, one of the purposes of the consent decree was public confidence. There are certainly other things that could happen in the city of Seattle with respect to policing that could undermine public confidence. For instance, response time to 911 calls or the rates of solving certain types of crimes. Even though those relate to public confidence, they wouldn't necessarily be things that the Department of Justice would view as part of the consent decree. So I do think there's a limit to what we're looking at. But to answer Your Honor's specific question, I think that these are all things, and we certainly welcome the court's thoughts on what we should be looking at when we are reviewing the city's final agreement, if it comes to that, with a collective bargaining agreement. At that time, we would be prepared to do a final review of whether or not we thought there was a conflict with the consent decree and to present that to the court. And we would hope that the court would then form its judgment about whether or not there was a conflict.
Your consent decree identifies the following areas which were to be the subject of these reform efforts: use of force, crisis intervention, stops and detentions, bias-free policing, supervision, and the Office of Professional Accountability. It seems to me if I'm asked to determine the purpose and terms of the consent decree, those are the things that I'm supposed to look at. And the kinds of topics that we're discussing right now are directly implicated in most of those. So, help me with this notion that somehow some things are going to kind of boil up to the surface and we'll look at those, as opposed to saying the purpose of the consent decree generally, which was application of constitutional policing.
Yes, Your Honor, I think there are, I would agree with the statement about the subject matters that the consent decree relates to. I believe that with respect to accountability, however, we only made certain limited findings with respect to OPA. Otherwise, we left issues of accountability to the city. Through our memorandum of understanding, and the consent decree, we found that as a general matter, those systems were sound, and that we left the review and decisions about whether or not to change those systems of accountability to the city. So I think under the express terms of the agreement and the MOU, that's a decision we have to defer to the city about. And certainly, as has been flagged here, there are some tough decisions to be made there, but I think it's appropriately within their purview, with the caveat that if any of that interferes with what the terms and purposes of the consent decree are, that would be an issue of concern to us. And so, if I may, Your Honor, I think...
Yeah, you should go ahead. I'll give you 5 minutes to wrap up.
Okay, thank you, Your Honor.
I won't ask any more questions.
Okay. If after the TA is passed, if it is passed, we would suggest that the city notify the court and DOJ, and that we then set a briefing schedule to brief the court on whatever potential conflict we see with the consent decree at that time, and then the judge could, Your Honor, you could reach your own determination of conflict. We would also urge, Your Honor, at that time, if you did find there was a conflict with the consent decree or a potential conflict, that you follow the procedure contemplated by paragraph 227 and refer that issue to DOJ and the city to attempt to find a solution to what that potential conflict would be. It may not be the case that we can resolve that conflict, but we think that would be a good first step. And if we are unable to resolve it, we would certainly brief the court and look to the court to make a judgment at that time. If we were able to reach a resolution, we would also plan to return to the court to brief you on what that proposed resolution would be. That's actually all I had at this time, Your Honor, unless you want to take back your promise and ask some additional questions.
227 reads, the city and the police agree to promptly notify DOJ if any term of the settlement agreement becomes subject to collective bargaining consultation. DOJ agrees to work in good faith to accomplish the goals through alternative means if necessary. Is that the language you're referring to?
I am, Your Honor, and I'm not suggesting that that necessarily governs in this instance. It's rather I'm suggesting that would be the best path forward. It would give the parties an opportunity to see if there was a way to resolve the issue.
Then I understand. Thank you.
Thank you.
Ms. Dugard? Same rules, you get 20 minutes. Don't pay any attention to that clock, which is still on daylight savings time.
My time is over before it began. Thank you very much, Your Honor, for inviting the Community Police Commission to talk with you today. I'm going to do my best to fairly represent the views of our entire commission, a group of incredibly principled people who have done a great deal of soul-searching about the situation that we find ourselves in. I thought, though, I might start by connecting the loop on the body camera question, which was not part of my prepared remarks.
You want to slow down just a little bit?
Sure.
So we'll get a full record.
Thank you. With respect to cameras, the court, of course, is correct that the Community Police Commission has not ever directly contended that body cameras were a strategy that all of our communities sought for the various constitutional policing issues that gave rise to the consent decree. That said, there is a lot of support for body cameras, certainly in certain communities, and that has been voiced by the Monitor team and by this court repeatedly. So to the extent that...
Hasn't it also been in your own polling, your polling that I've seen rates it at higher than 80% community support?
We didn't actually conduct that polling, but there's no question that, I will say, this could be a big rabbit hole for us, but nationally, dialogue around cameras is really complicated. When in cases of misconduct, it's great to have cameras. The reason that some communities have reticence about it, particularly non-citizen communities, is because of other uses of surveillance and sort of unintended consequences. And it's been a struggle for us to wrestle with this technology as a solution to complex problems. That said, we fully acknowledge that the Monitor team has been on record for a long time, and this court has also indicated a belief that cameras would be a useful mechanism to address use of force and other issues. That said, the department is using them. Then Mayor Burgess issued an executive order requiring that in the aftermath of certain high-profile events in the community. And my own sense, for listening to the conversation today, is that the compliance issue, if there were one, would arise if the department did discontinue the use of cameras and not require their use, or allow it to be a voluntary opt-in for officers. That's not my sense of the situation, and I think if that became the situation, you would hear about it from one or more parties or the monitoring team.
Well, that's why I keep picking at this, because that's how it's reported in some of the better reporting that I've seen. And, you know, I've been on record for a long time as saying very bluntly to SPOG, I'm not going to allow them to blackmail the people of Seattle for higher wages in order to receive constitutional policing. I don't know how to say that any more bluntly. On the other hand, I know that they are underpaid by the standards of other cities, and I'd like to see that corrected promptly. But what we're creating is a situation where a select group of officers don't want to carry body cameras and are willing to take the 2% pay reduction, or at least not receiving the bonus, so that they can continue to engage in potential behavior, which I think the majority of the people of Seattle think is a good thing. And, you know, that's what, and then there may be lots more. You have far and away the lead in terms of material out there criticizing the tentative agreement. I don't want answers today as much as I want to highlight some of these things, so that, you know, we can understand where we are.
It would be, the commission would not be the best voice with respect to either city policy, department intentions, or the intent behind the tentative agreement, but I will say that we worked on the policy implementing the body camera, the decision to implement body cameras department-wide. That too was contentious. It is our perception that the department is directing that they be used comprehensively and not as an opt-in. My sense is that this concept of pay for wearing body cameras is perhaps an inapt way of describing making wages competitive and appropriate, and maybe that would have been a more direct way of describing what the agreement accomplishes. And we support that, just to get to the thrust of the Commission's core position here. We absolutely agree that it's not just that officers deserve a wage increase and fair and competitive wages. The city has its own need to pay fair and competitive wages. There's no point in us talking about preference points to hire officers who have language skills or diverse background when the department has to hire literally anybody who qualifies, and that is a challenge that we as well are eager to see met. So we absolutely do not want to stand in the way of immediate delivery of those wage agreements.
Okay, I've led you off into the weeds. Why don't you get back to your main agenda?
Thank you, Judge. So as is explained in our brief, we only see one specific provision of the tentative agreement that is in possible tension with this court's orders implementing the consent decree, and that is, as the United States also mentioned, the introduction of an undefined elevated standard of review for all termination decisions when they are appealed. This arguably contravenes the court's rejection of an elevated standard for termination in initial cases of dishonesty, although whether it does so depends on whether Your Honor was primarily concerned about treating dishonesty differently or was primarily concerned about the difficulty of sustaining a termination in important cases. So was it the elevated standard or was it treating dishonesty differently? If the former, then there isn't an issue in the consent decree because all bases of termination are now treated the same way. But if the latter, this provision of the contract may contravene the court's prior direction. More generally, and to the heart of the matter, we do consider that the contract undermines one of the core goals of the consent decree. And those goals, as defined in the decree itself, are to ensure that police services are delivered to the people of Seattle in a manner that fully complies with the Constitution and laws of the United States.
Slower again.
Sorry. Effectively ensures public and officer safety, and for us the key, promotes public confidence in the Seattle Police Department and its officers. The rest of my remarks focus on this concern. As the court is aware, the CPC voted unanimously a few weeks ago to oppose the SPOG Police Officers Guild contract as presently negotiated. This is a position that most of us took very reluctantly. First, because we value SPOG and its members as essential partners in reform. Second, because we understand and respect the collective bargaining rights of police officers and sergeants as public employees. Third, because we recognize the intense pressure on Mayor Durkin, Chief Best, and the City Council to pay competitive and appropriate wages, as well as to acknowledge the exceptional work of many rank-and-file officers and sergeants in recent years. And fourth, because we do recognize that police reform is broader and deeper than just the formal structures for holding employees accountable for misconduct. That said, although reform is broader than police accountability and formal mechanisms of investigating misconduct and imposing discipline, unquestionably, as the Community Police Commission, we have to acknowledge that those issues are of paramount concern to the communities that we represent and that we are accountable to. On the first point I named, we value and respect SPOG and its members as partners. For the past 6 years, we have resisted frequent invitations from reporters and activists to pit the police unions against community civil rights groups. We've said publicly many times, including in this court, that contrary to the expectations of some, including some commissioners, SPOG has not impeded reform. In so doing, we were swimming upstream against the dominant narrative locally and dog whistles nationally that police unions and their contracts are a major threat to the transformation of policing. We pushed to retain police union representation on the commission when the commission was made permanent in last year's accountability ordinance, although it would have been politically possible and maybe easier to eliminate those positions. We have valued the views and input of SPOG and its rank-and-file members in the development of our policy positions, and on occasion, most significantly in discussions leading to the first revision of the use of force policy, we have been a channel for their insights to be heard when other channels were closed. We bought every commissioner, I brought a prop, Your Honor, David Sklansky's book, Police Reform from the Bottom Up, Officers and Their Unions as Agents of Change. which argues that true and lasting reform of policing necessarily entails a voluntary meeting of the minds with the rank and file, the men and women who do the very difficult, often unpleasant, and sometimes dangerous work that we as a society have assigned to the police force. In all respects, we have tried to play our community oversight role since 2013 in a way that fosters respect for SPOG and its members as essential partners. The CPC's open stance towards SPOG surprised many in the community and probably also many within SPOG. But we committed to it because we were about lasting change, not about scoring points or winning battles while losing the war. We committed to trying to build a willing and mutually respectful partnership with rank-and-file officers. Our accountability reform recommendations were also consistent with those values, as we held open the possible importance of retaining sworn investigators in OPA because of their knowledge and expertise. And we signed on to reducing the overall volume of cases investigated by OPA and returning responsibility for many investigations to line supervisors. Again, these were not predictable positions for us, and in fact, for those of us who came out of a background in police reform advocacy, they represented a substantial shift in position to embracing the importance to accountability of internal supervision and internal leadership. On the second point I made above, we understand and respect the collective bargaining rights of public employee union members. The CPC was given primary responsibility under the consent decree and the associated MOU to review Seattle's police accountability structures and processes and to make recommendations for improvements to increase their effectiveness and improve community confidence. Knowing that some aspects of accountability systems have to be bargained, we pressed hard throughout the winter and spring of 2014, the last year of the prior contract, to finish our review and make recommendations to avoid any question that those recommendations might constitute an unfair labor practice. Accordingly, almost every aspect of the accountability ordinance ultimately passed last year had already been identified by the CPC in 2014 in time to be included in the city's initial direction to its bargaining team. We have not taken a knee-jerk critical stance toward contracts with Seattle's police unions, even when they have set back some of the accountability reforms we recommended. It's important to recall that we were generally supportive of the Seattle Police Management Association contract when it was before the City Council for approval a year ago, even though it included important deviations from the accountability ordinance that we and many others had struggled for nearly 4 years to adopt. We recognize that bargaining is necessarily a process of compromise and problem solving, and we helped explain that to the communities we represent. We took this position even though the SPMA contract, among other things, undermined the single route of appeal from disciplinary decisions that 3 expert reports found in spring 2014 was necessary to prevent abuse and maintain community confidence in the accountability system. We carried a lot of water on the SPMA contract with the media and community leaders. This carrying of water was not a whim, but rather it is what the CPC was designed to do under the consent decree and the MOU to gain community legitimacy and trust. The consent decree set us up to play that crucial brokerage role. And I'm quoting the community from the consent decree. The community is a critical resource. Certain aspects of the reform efforts embodied in the agreements are best developed by dialogue and widespread input. Moreover, ongoing community input into the development of reforms, the establishment of police priorities, and mechanisms to promote community confidence in SPD will strengthen SPD and facilitate police-community relationships necessary to promote public safety. We have often, in keeping with that approach, which I think was unusual and quite visionary, we've often been asked to step in and vouch for the viability of the ongoing police reform process with communities who have well-founded reason to be skeptical and mistrustful. After the events in Ferguson, Missouri in August 2014, and with rising unrest nationally that November when the officer who killed Michael Brown was not indicted, then Mayor Murray called a press conference in which he said that Seattle would not be like Ferguson in significant part because of the Community Police Commission and the work we had done to propose improvements to the accountability system. We all stood there as the mayor made promises about accomplishing those reforms in order to gain community confidence. Similarly, it was us who faced angry and despairing community members after Charlena Lyles was killed, despite all the commendable crisis intervention and de-escalation training that was accomplished under the consent decree. And it was us who made the case to those angry and despairing people that the new accountability ordinance put in place a carefully designed system that should be capable of identifying avoidable instances of deadly force and proposing improvements in training or practice. Regarding the third point, the pressure that our city leaders are under, we do see that Mayor Durkin, Chief Best, and the current council face urgent challenges in retaining and recruiting officers, challenges that arise both from wages that are no longer competitive and from a deep and well-grounded feeling that SPD's employees have not received appropriate respect for their dedicated and innovative work in recent years. So for all of these reasons, Your Honor, when we received the tentative agreement with SPOG on October 1st, most of us assumed we would play the same role as we had with the SPMA contract, identifying places where there is still work to do, explaining to the communities we represent that bargaining is inherently a process of refinement, being generally supportive to back the elected leaders who would need to vote yes, and calling on our communities to move forward with the work of construction and innovation. We were taken aback when we received the actual proposed contract. After we registered how profoundly compromised the accountability ordinance was by the contract, or would be, we realized that we could not in good conscience turn to the many community leaders who pushed for the adoption of that law and tell them that that basic approach was still more or less intact. Trade-offs were made, and many or most of the changes we had lifted up based on years of community experience and study were left on the side of the road. Most of the proposed changes that we had identified had a specific name, a person's name, and a past system failure attached to it. These problems had been identified through critical review of actual misconduct investigation done over the years by the OPA auditor or by particular community leaders. They were not theoretical improvements, but they were fixes for known actual problems. The elimination of the 180-day time limit for discipline when misconduct can be proven was a response to William Wingate's case. He was the man wrongfully arrested while taking a walk with a golf club, where Chief O'Toole's dismissal of the officer involved couldn't be sustained because OPA didn't get the complaint in time to finish its investigation within 180 days. In our review of the contract, that case would unfold in the same way today as it did several years ago. The single avenue for disciplinary appeals was a response to Dominic Holden's case. He was the reporter who was video recording an officer making an arrest, who in turn was threatened with retaliation by the officer. The officer's suspension for that sustained misconduct was reversed when the department agreed to settle a large group of cases that were pending appeal, and in the ensuing scandal, this was in spring 2014, no fewer than 3 expert reports found that it was essential to eliminate multiple avenues for appeal. They weren't eliminated, and the SPOG contract preserves 3 avenues of appeal.
You're running out of time, Counsel.
Thank you, Your Honor. I'll just mention that action to reform the secondary employment situation flowed from a 2017 FBI investigation into threats and intimidation in the secondary employment market for Seattle police officers, potential corruption that was surfaced by principled SPD officers themselves, and which then Mayor Burgess attempted to address through an executive order. This contract explicitly restores conditions from 1992 and just provides a reopener for these issues. I understand I'm at the end of my time. I will just say that the straw that broke the camel's back for us is no one of these points. It is the fact that unlike the SPMA contract, which recognizes the integrity of the accountability ordinance except where the contract specifically negotiates to the contrary, the SPOG framework is the opposite and says that when there's a conflict between the contract and the ordinance, the contract wins. And a conflict is potentially any place where the contract covers the same ground as the ordinance but does so differently. Not only is that it turns the ordinance into Swiss cheese, but it also creates great confusion about what the rules are. And this is the core of our concern about community trust and confidence in the system itself.
So do you have a recommendation to the City Council?
We, in the absence of any other step, recommended that the council not adopt this contract, and that, of course, would be an extraordinary step. There is no other way to back up. We would have, if we had more power, we would have insisted that we be involved at the table as technical advisors, which is lawful. And in that way, we could have put up the yellow card earlier and said, this is not going to fly, can we try another way through it? We were not, and at this point, we have very limited options. Your Honor, our suggestion about the way forward is not apocalyptic. There could be, extreme reactions, but on the other hand, leadership for the union and the city could engage in problem solving, and we hope that this is the direction that is taken. We would like to see the parties go back to their respective decision makers, and in this case of SPOG, that may be the membership, to move forward a revised contract that accepts all of the provisions other than those that pertain to accountability immediately, including wages, and has an immediate reopener on the measures, on the portions that pertain to accountability. And if that happens, we can just immediately, by right, not by grace of the parties, but by right, commence a dialogue about how to get to a win-win outcome here, one that we would be happy to assist with, and we hope that the city would avail themselves of us and the other oversight bodies as technical advisors. And I'll stop there unless the court has additional questions.
I think I'm fine. Thank you.
Thank you.
Ms. Coward, I'll give you the last word. I guess technically I am the last word, but I'd like to hear your rebuttal.
Thank you, Your Honor. I'd like to briefly clarify that the tentative agreement does not allow officers to opt out of the body-worn video requirement, to the extent I was unclear about that earlier. The body-worn video policy of the police department that was approved by the monitoring team and the Department of Justice and the court previously, that policy remains in effect.
All right. And the agreement will tell us the answer to that.
Sorry, could you
I think
repeat
the
that?
agreement will tell us the answer to that.
So the tentative agreement, the relevant provision is section 6.5.2, and the relevant language states, an additional 2% of the base monthly top step salary held by the affected employee shall be paid to employees required to wear body-worn video while on duty for the city. Patrol officers are required to wear body-worn video, and I can't say off the top of my head which other units may or not be required to be. Some employees are in units that are not regularly required to wear body-worn video, but are sometimes required to wear body-worn video. And the TA does provide for additional circumstances for those employees.
All right.
And I'll conclude.
Well, my thanks to counsel for appearing here today. I think we have highlighted the fact that not only is there a controversy over the tentative agreement, but there is a controversy over where do we go from here. I'm always interested to hear from the parties. I think there is some hyperbole in the presentations that are made by the three groups that spoke today. For example, and I'll apologize to Ms. Dugard in advance if I'm wrong, the word primary is never used in terms of responsibilities of the CPC in regards to the accountability ordinance. But it's a long document, and maybe I missed that. When the city takes the position that there is nothing in there that's inconsistent with the consent decree, I don't believe that to be accurate. And in regards to the United States, I'm not sure that I managed to pin them down to any particular provision, but it's clear that they're holding their position on the contract close to the vest. I will tell you that in the course of time since the consent decree was signed and this matter was assigned to me, I have valued the sworn officers' willingness to embrace reforms, and I believe that to be a vast majority of the force. I encounter members of the force who repeatedly tell me that they'll be here long after I'm gone, and that's been the situation for decades, that there have been previous reform efforts, and the police have always managed to outlast any reformer. I believe that we have made fundamental changes, and they're for the best. I value Chief Best. I value Chief O'Toole's efforts while she was with us. The provisions that the spirit of the consent agreement to me is a reinforcement of the authority of the chief and of civilian management of the department. And consequently, I put a high premium on leadership. I champion the improvements which have been made in the department. Some we can measure statistically, some are implicit in attending a Washington Husky football game and hearing the public's interaction with the people directing traffic, where you hear comments like, hope you're having a good day, positive reinforcement being given to the force. I'm also mindful that we have a continued problem in terms of portions of the citizenry of Seattle. I'm dismayed that we don't have a greater representation of the variety of people who live in our community attending these hearings. I will tell you, you were better behaved than the high school class that was here this morning. I started off saying that I am not going to weigh in on the tentative agreement. That's up to the City Council, but I want it clearly understood by everyone that after the situation reaches the point that it is appropriate for federal court review to see how the entire situation lines up against the provisions, and I'll use the word, the spirit and purposes of the consent decree, the court will fully exercise its authority to conduct that investigation. Counsel, I know I dragged you in here on shortened notice. I appreciate you accommodating the court's need to change the date, and I will look forward to receiving your further submissions on what happens next. We will be in recess. Thank you, counsel.
All rise. Court is in recess.